When can you call the defense expert a liar at trial? Would you like to learn the answer? Come join me as I share with you this great information. Hi, I'm Gerry Oginski. I'm a New York personal injury and medical malpractice trial lawyer practicing law here in the state of New York. You're at trial and the defense expert gets up and they says some outrageous things that just get your blood boiling, and you know that they're wrong, and you know that they're telling you something that's absolutely untrue. When can the attorney get up and call that defense expert a liar? Now here's something fascinating. Technically, you really don't want to call any particular witness a liar. You don't want to call it to their face. Instead, you ask cross-examination questions that are going to show that this witness is lying without actually coming out and calling him a bold-faced liar. The jury will know by the questions that you're asking when you're able to show and contradict the statements that this particular expert is saying, without ever having to come out and accuse the person to their face, aren't you a liar? They're obviously going to get defensive and say no. And if you now get all up in their face and you start to accuse them of being a bold-faced liar, two things can happen. One is that the jury will resent the fact that I'm so aggressive and in their face. And two, they might actually take pity on this witness even if he is lying. So one of the better tactics and strategies to use during trial is to establish, through the use of cross-examination, and establish contradictions about the witness's testimony. And to do it consistently and build your entire case by building a foundation of showing numerous inconsistencies. And then at the very end, on closing argument, turn to the jury and again, without ever calling this person a bold-faced liar, establish one contradiction after the next, and ask the jury, is this somebody that you can believe? Is this somebody you can put your trust in? Is this somebody whose testimony you believe is actually true? And you know, there's something in the law called falsus in uno. And what that means is that at the end of the case, the judge actually instructs the jury and tells them, listen, if you find that a witness has testified falsely about one particular thing, whether it's a small thing or a big thing, you are entitled to disregard all of their testimony. And that's a much better strategy rather than coming right out and accusing somebody and calling somebody a bold-faced liar right to their face, or even during closing arguments. So why do I share this great information with you? I share it with you just to give you a quick bit of information about what goes on during the course of trial, especially during cross-examination of an expert witness. In all likelihood, you have questions or concerns about your own particular matter, and if your matter happened here in New York and you do have legal questions, what I encourage you to do is pick up the phone and call me. I can answer your legal questions. This is something I do every single day, and I welcome your call. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at oginski-law.com. Well, that's it for today's quick video. I'm Gerry Oginski. Have a wonderful day.